Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on section 151 where approval is to be taken from Principal Commissioner of Income Tax where the period is up to 3 years and where the period is beyond 3 years, then the approval of Principal Chief Commissioner of Income Tax is required. The issue was that when the first proviso to section 151 was introduced from 1st April 2023, which gives the revenue to exclude the period for giving the reply against the notice under section 148A clause B for calculating whether the approval of PCIT is required or PCCIT is required, whether that is applicable from previous years also, that is before 1st April 2023 also. This issue has been taken up by Telangana High Court in the case of Deloitte Consulting India Private Limited versus Assessment Unit, Income Tax Department, and this case is reported in 481 ITR at page number 175, and the date of the judgment is 25th September 2025. In the present case, the notice under section 148 was issued to the assessee for the assessment year 18-19 on 7th April 2022. When this notice was issued, for issuing this notice, the show cause notice under section 148A clause B was issued to the assessee before 31st March 2022. And when ultimately the notice under section 148 was issued to the assessee and the approval was taken, then the approval was taken from the PCIT. It was the submission of the assessee that since from the assessment year 18-19, 3 years have passed on 7th April 2022, then in that case the approval of PCCIT was required, and since the approval was taken from the PCIT, so the notice is bad in law. But the revenue was harping on the concept which was introduced by the Income Tax Act from 1st April 2023 by the Finance Act 2023, that the time period which was given to the assessee for giving reply to section 148A clause B notice should be excluded for reckoning whether the permission is to be taken from PCIT or from PCCIT. When the matter was before the Telangana High Court, because the assessment proceedings were completed without entertaining this ground of the assessee, so when the court heard the matter, the court said that in the present case there was no doubt that the period of 3 years have elapsed on the date of issue of notice under section 148, that is 7th April 2022. The court said that in the income tax proceedings there is no scope of any indentment, or the indentment cannot be assumed in income tax proceedings. The court said that the period consumed in furnishing the reply will not be excluded for the notices which have been issued before 1st April 2023, and in the present case, since the notice under section 148 has been issued on 7th April 2022 for the assessment year 18-19, so clearly 3 years have passed. So in the present case, if we read section 151, so according to that, in the present case, the approval of Principal Chief Commissioner of Income Tax or Principal Director General of Income Tax or Chief Commissioner of Income Tax or Director General of Income Tax was required, and since in the present case no approval was taken from these authorities but the approval was taken from the Principal Commissioner of Income Tax, so the assessment is bad in law. Friends, this case is very important because this mistake has happened on the part of the revenue, especially for the assessment year 17, 18 and 18, 19 in maximum number of cases where the notices has been issued by showing the show cause notice under section 148A clause B in March, and consequently the notice under section 148 was issued beyond that. So this case is very helpful to determine the validity of those assessments. At the end of this video, once again I am repeating the name of the case. The name of the case is Deloitte Consulting India Private Limited versus Assessment Unit, Income Tax Department, and this case is reported in 481 ITR at page number 175, and the date of the judgment is 25th September 2025. Thank you, friends.